Good morning everyone and welcome to today's webinar, which is our 2024 Spring Update. So since our last annual update, which was in October, things have moved on quite a bit in the market and we're really pleased to see that transactions are starting to re-emerge. Inflation has been coming down and lenders are seeing interest rates reduced to a level where servicing debt is becoming more affordable. There's also been some price rebasing and stabilising, which is something many of our clients have been waiting for. We've come through a period of uncertainty in the market, where there was a friction between sellers who didn't want to accept that the market had shifted, and buyers who wouldn't jump to buy in circumstances where they weren't quite sure if the market had reached the bottom of the curve. Anecdotally, the talk was of people being more cautious overall. So at the height of the market, a buyer would do a deal knowing that it would be profitable. The question was just how profitable would it be? This is no longer the case, and buyers really have to be much more careful to fully review and investigate every aspect of a deal. Funders in particular have taken a very conservative approach to risk on the whole, which is understandable in the economic climate. We are now seeing a welcome return to some urgency in deals, which is driving them to proceed more quickly again, in contrast to the sluggish deals of the last 18 months or so. It often seemed to take forever and involved various false starts and changes to the terms throughout. There's a definite sense now that people want to get deals done and they want to get them done quickly. Now, possibly this is partly to do with the underlying assumption that a change in government is likely in the not too distant future, and the fact that that might take us back into a state of uncertainty. But whatever the reason, it's refreshing and it will hopefully continue. The Office of National Statistics last week confirmed that the economy grew slightly by 0.2%, that was in January, following a slight decline in December. There has been strong growth in retail and wholesaling, and the ONS has also reported that construction performed well, with house builders having a good month. This has led to hopes that the country is re-emerging from the so-called technical recession it went into, which was following 2 quarters of negative growth in the second half of 2023. So the recent budget, it was pretty benign from a commercial property perspective. Those who invest in residential property will have been disappointed to see the loss of multiple dwellings relief and the furnished holiday lettings regime. The reduction in the rate of residential property capital gains tax from 28% to 24% may soothe things slightly. We may start to see more landlords and second homeowners putting their properties on the market in the hope of benefiting from this reduction. And this will hopefully stimulate the market, perhaps at the lower end of the range. Some of you may have seen the recent Deloitte Crane survey. That showed that Manchester continues to perform well in terms of the number of schemes being completed and under construction. Completions have been slow in 2023, but levels are set to recover in 2024 and 2025, based on current levels of construction activity. Despite the post-pandemic discussion around the office being dead, there have been a number of high-profile lettings in the city centre, and actually law firms seem to be at the forefront of this. The reports continue to be that ESG credentials are forming a more significant part of occupier demand. Businesses are seeking to meet their organisational ESG credentials and also to attract the best talent. Build-to-rent developments and purpose-built student accommodation are also extremely strong within the city. So I think overall it does seem that it's a much more positive start to 2024, and certainly there's much to build on in the coming months. So back to today, we're going to hear from 3 of the team with an update on several topical areas of interest. We will firstly hear from Sarah Cohen, who's going to discuss sustainability issues in leases. We're more and more being asked to advise on lease provisions regarding environmental and other ESG obligations, both during the term of an existing lease and also on renewal. So who's obliged to or is able to carry out works to improve sustainability or to measure, say, how efficient a building is, and who's obliged to pay for those works, most importantly. What then happens on the renewal of a lease? What counts as reasonable updating here in that context? Sarah will then talk about solar and electric vehicle charging leases, again something we find that we're advising on more and more. Laura Pyle will then take us through rights to light, a topic that makes a lot of us scratch our heads a bit. We picture trying to calculate how much light is an adequate light through an aperture and what the angle of that light would be. We thought it would be a useful reminder of the legal principles now that development is very much back on the agenda. Then finally, Karen Taylor will update us on the proposed leasehold reform in relation to both residential and commercial tenancies. There's certainly a lot going on there. Karen will also take us through the most important cases which have been decided in the past few months. So firstly, it's over to Sarah.
Thanks, Jo. Morning, everyone. I'm going to talk about sustainability in leases and green lease drafting, followed by an overview of points to consider in relation to solar farm and EV charging point leases. Climate change concerns have led to a greater focus on energy efficiency in buildings. According to the UK Green Building Council, the built environment contributes to around 40% of the UK's total greenhouse gas emissions. UK government policies are beginning to oblige developers, landlords and occupiers to focus on the environmental performance and sustainability of buildings. The UK government has set a legislative target of 78% reduction in greenhouse gases by 2035 and a target to achieve net zero by 2050. With a shift in focus towards sustainability and achieving net zero targets, green lease provisions can allow landlords and tenants to work collaboratively to improve environmental efficiency, sustainability and achieve net zero targets. Green lease drafting is drafting that provides for the landlord and the tenant to undertake specific responsibilities and obligations to minimise carbon emissions arising from the sustainable development, operation and occupation of a property. The RICS Code for Leasing Business Premises, in its lease negotiation and best practice section, states that parties are encouraged to include lease provisions relating to sustainability and the environment that urge cooperation throughout the lease term between the landlord and the tenant to ensure that the property is used as sustainably as possible. The Better Buildings Partnership recommends that for both new and renewal leases, owners and occupiers should try to include green lease clauses. As a minimum, these should include provisions regarding sharing of data and cooperation on improving environmental performance. Landlords and tenants are not legally obliged to include green lease provisions within the leases. It's of course up to the parties to agree to include green provisions, along with the scope and nature of these when negotiating the lease. Light green provisions commit both parties to principles which are usually not legally binding and are aspirational or limited in scope. Light green provisions may be used where the parties are limited in their resources and/or their sustainability targets. Medium green provisions tend to create obligations on the parties, but these obligations are not intended to impose an unreasonable economic burden on the parties or require them to act commercially unreasonably. Medium green provisions are appropriate where the parties are reasonably well resourced and have set sustainability targets. Dark green provisions are specific in nature. They can be legally binding and they place a greater onus on both parties. A breach might result in forfeiture of the lease unless agreed otherwise. Dark green provisions will only be appropriate where the parties are well resourced and have set public and/or binding net zero targets. The incorporation of green clauses is not limited to new or renewal leases. Where a lease is already in place, green lease provisions can be included by way of a memorandum of understanding. That's a non-binding agreement between the parties which will provide for cooperation between the parties to increase the environmental performance of the building. In new lettings, we're seeing landlords try to include a range of provisions to tackle climate change or to shift the cost burden of compliance with the MEES regulations onto the tenant. Generally, these provisions relate to data sharing, for example, utilities consumption, cooperation to identify strategies to improve the environmental performance of the building, using sustainable materials for repairs and alterations, restrictions on the tenant carrying out alterations to the premises which might adversely affect the EPC rating of the premises or the building. Usually the reservation of additional rights, so the landlord can enter the premises to carry out works to improve the energy efficiency of the premises or the building so that it can ensure compliance with the MEES obligations. And finally, additional service costs being included as part of the service charge. Landlords might also try to include these clauses at lease renewal, but they may be faced with opposition. The starting point on renewal under the 1954 Act is to seek renewal on the terms of the old lease. the old lease is likely to include inadequate energy efficiency related provisions or none at all. Following the principles set out in the 1983 decision of O'May, which many of you will be familiar with, the court will only order new terms that they consider to be fair and reasonable in the circumstances. The burden of persuading a court to change the terms of the current tenancy sits with the party proposing the change. Updating a clause to take account of legislative updates may amount to reasonable modernisation, but this won't apply to all green lease clauses. County court cases suggest that landlords may have difficulties introducing new green lease clauses, unless the tenant agrees to them. In the case of Clipper Logistics in 2022, the Sheffield County Court held that the landlord could not introduce certain green lease provisions into the renewal lease. The landlord was seeking new covenants prohibiting the tenant from carrying out alterations to the property, which would result in the property having an EPC rating below E, an indemnity from the tenant for the cost of obtaining a new EPC certificate if alterations invalidated or adversely affected the existing EPC, and a provision requiring the tenant to return the premises to the landlord at the end of the term with at least the current EPC rating. The court found that as the lease prevented the tenant from making internal non-structural alterations without the landlord's consent, the landlord already had sufficient protection. They were of the view that the new clauses were unfairly and unreasonably shifting the burden of regulatory compliance onto the tenant. However, the court did find that the renewal lease should include an obligation on the tenant to maintain the current EPC rating and return the property with the same EPC rating as at the start of the term. In the Saville-Adels case in 2021, which is another county court judgment, the landlord wanted to change the terms of the existing lease to include specific provisions. They were to grant access to an energy assessor, to cooperate with the landlord in the obtaining of an EPC, to prohibit the tenant from obtaining its own EPC, or if one was required by the tenant to use an energy assessor selected by the landlord, and to deliver a copy of the EPC to the landlord, and to prohibit works that would result in the premises becoming substandard under the MEES regulations. The existing lease already included a right of access for any reasonable purpose. The landlord's new provisions were rejected by the court. It regarded the clauses as unnecessary for the protection of the landlord's position, although it appears the judge focused more upon the requested right of access, which was already adequately provided for in the existing lease, rather than the prohibition on works rendering the premises substandard. The cases suggest that whilst the courts appreciate the heavy burden imposed on landlords by the MEES regulations, they may not tolerate landlords' attempts to offload that liability, where that would impose new and additional burdens on tenants. Although non-binding, these decisions suggest that some difficulties could be encountered with green leases at lease renewal. There is a feeling generally that the 1954 Act in its current form is inhibiting the push for sustainability. Reform of the 1954 Act is proposed, and as Karen will talk about shortly, it is hoped that this will give greater clarity on determination of renewal terms. Turning now to solar farm and EV charging leases. At the end of last year, the UAE hosted COP28, which saw significant commitments aimed at combating climate change, including a commitment to triple renewable energy capacity by 2030 and the acceleration of the rollout of electric charging infrastructure. Currently, the UK's total solar capacity stands at 15.7 gigawatts, and the government aims to increase this substantially to 70 gigawatts by 2035. Research shows that as of July last year, new solar sites being scoped and planned have reached a total planned capacity of more than 85 gigawatts across approximately 1,250 sites. The Zero Emission Vehicle or ZEV mandate, which came into force in January this year, sets out the percentage of new zero emission vehicles that manufacturers will be required to produce each year. This requires 80% of new cars and 70% of new vans sold in Great Britain to be zero emission by 2030, increasing to an ambitious 100% by 2035. Such widespread take-up and use of EVs across the UK's transport network will require significant development of infrastructure. Research suggests that by 2030, the UK is likely to need around 400,000 public charge points, including around 6,000 high-powered charge points. The UK's increasing need for solar sites and EV charging points presents opportunities for landowners. I'm going to briefly discuss the advantages, practical considerations and drafting points of solar farm and EVCP leases. Looking first at solar projects. The industry widely quotes around £1,000 per acre returns for renting land for large solar PV developments. Solar farm leases often last between 25 and 40 years, and the landowner will have a guaranteed source of income from the land for that term. Rents are generally index-linked, meaning that rents keep up with inflation throughout the lease term. Turnover rents offer another incentive for landowners, with many achieving percentages of around 4 to 6%. This means that where the specified percentage of the developer's revenue exceeds the acreage-based rent, the landowner is paid a top-up between the two figures. In terms of practical considerations, landowners interested in leasing their land for solar power generation will need to find out if they have a grid connection located on their land or in the vicinity, with surplus power in the local area. In terms of planning, some permitted development rights exist for rooftop solar PV panels, but for a solar farm, a planning application will need to be made in the normal way. It's unlikely that a solar farm will receive planning consent if the land is located within an AONB or a national park. Landowners will usually be required to grant the renewable energy developer an option over their land for a period of between, say, 3 and 5 years. This is while the developer secures a grid connection and planning permission for the project. Landowners should be aware that the land will effectively be sterilised during that option period. Restrictive covenants, easements and third-party occupational interests may impact or prevent the proposed installation of solar PV panels. The developer will usually instruct its solicitors to carry out a full due diligence exercise before the option agreement is entered into to flush out any potential issues. The landowner may require consents from existing utility providers to install the associated cabling and other infrastructure for the project. If cabling needs to run through neighbouring land, the landowner will require an easement. Where the land is mortgaged, the consent of the lender will of course need to be obtained. And if the landlord's interest is leasehold, consent will also be required from the superior landlord. Moving on to drafting points, as I've already said, the term is usually between 25 and 40 years. There will often be an option to renew for a further term of 10 years. Rent can be fixed or on a turnover rent structure. The base rent will usually be subject to annual RPI-linked increases. Solar leases will grant the tenant a right of uninterrupted passage of light to the solar panels, for obvious reasons, and the landowner will not be able to do anything on its adjoining land that would restrict the light flow to the solar panels. The lease is also likely to contain covenants, not to do anything on the land, which would damage any electric cables or wires, and not to deal with the land in any way that could be otherwise detrimental to the solar project. One of the most important aspects to be agreed on is reinstatement. Many renewable energy companies are SPVs with few or no assets. The SPV could easily be dissolved, exposing the landowner to the liability of having to dispose of panels and cabling and reinstate the land itself. Landowners should ensure that the lease includes arrangements for a decommissioning bond, either accumulated throughout the lease or set aside from day one. The landowner would be entitled to withdraw from the security if the developer failed to comply with its reinstatement obligations within a reasonable period after lease expiry. Landowners should also ensure developers produce an agreed schedule of condition before the commencement of works to install the solar facility. The lease should provide for the developer to return the land to this condition once the project ends. The lease should also contain an indemnity from the developer in respect of any environmental liabilities relating to hazardous materials that are brought onto the land by the developer. If the landlord forfeits the lease because of a breach of covenant or non-payment of rent, consider whether the tenant should be required to leave the solar panels on the land until all monies due to the landlord have been paid. Solar panels are a valuable asset and could be used to offset any debt owed to the landlord. So, what about EVCP leases? Landlords who provide amenities on their sites such as Wi-Fi, food and beverages and toilet facilities might want to consider the benefits of establishing a public charging hub within their site. Savills have reported that rents are currently tending to range between £2,000 and £4,000 per charger per year, with index-linked uplifts, cap and collared at typically between 1% and 3%. Other lease structures exist, with some EVCP operators offering a lower base rent of between £1,000 and £1,500 per year per charger. Again, that would be index linked with a collaring cap, plus a 10 to 15% gross profit share. In terms of practical considerations, clearly the first step is for the EVCP operator to consider whether the existing electricity supply is sufficient for the EV charging infrastructure requirements, or whether additional infrastructure such as an electricity substation will be required. The operator will also need to secure a point of connection. At the outset, the operator would need to contact the DNO to understand their requirements. Under the Planning Acts, the installation of EV charging points is considered development and requires planning permission. However, under general permitted development rights, planning permission is not required for the installation of wall-mounted electrical outlets or upstanding EV charge points, provided that there is no Article 4 direction removing general permitted development rights. A solicitor will be able to check this for you. As I mentioned in the context of solar projects, restrictive covenants, easements and leases might impact or prevent the proposed installation of the charges. If the affected land is subject to a lease, then a licence or deed of variation might be needed to allow the operator access for the installation, connection, operation and maintenance of the EV chargers, and once the chargers have been installed, to reserve rights for third parties to use them. Again, the landowner might need consents from existing utility providers to install the EV charging points and the associated cabling and other infrastructure. And if cabling needs to run through neighbouring land, an easement will be required. Again, consider whether consent is required from any mortgage lender or superior landlord. Landowners should consider whether the installation of EV charge points will impact the building's insurance policy or any other policies already in place, such as public and employers' liability insurance. Moving on to drafting points, we would generally expect to see lease terms of between 10 and 15 years, which is equal to the lifespan of the infrastructure. As with solar leases, rent can be fixed or on a turnover rent structure. If a turnover structure is agreed, the EVCP operator would pay a base rent per charging point, with a top-up rent based on a percentage of net profit earned. The base rent will usually be subject to annual RPI-linked increases. Operators are generally looking for leases within the Landlord and Tenant Act 1954, and landowners will naturally want the lease to be contracted out. This is a point for negotiation, and we've seen both tenancies inside the Act and outside the Act. The operator would be granted rights to install, connect, operate and maintain the charging points. The EV operator will be required to undertake general repair and maintenance works to the charging infrastructure and to ensure it's operating in a safe manner in compliance with all regulatory requirements. The parties should consider whether the operator will remove the charging infrastructure at the end of the term or whether the landlord could buy it so that it remains in situ on lease expiry. The operator may prefer to leave the charging infrastructure and any underground cabling in place, as it might not be practical or cost effective to remove it. It's best to agree a reinstatement programme before the lease is entered into, so both parties know exactly what's required on lease expiry. The operator might require a right of exclusivity over the landlord's property, which prevents the landlord from leasing any other parts of the property to other EVCP operators. Or the operator might request a right of first refusal over any other parts of the property that the landlord intends to use for EV charging. Leases will include restrictions on the landlord's ability to redevelop. Landowners will be keen to include a lift and shift clause requiring the operator to relocate equipment where required for development purposes, but the operator will want to ensure that it can recover its costs, so it's unlikely to agree to a lift and shift provision within, say, the first 2 or 3 years of the lease, without expecting to be reimbursed by the landlord for its capital expenditure. I hope this provided a helpful overview of the topic. If you have any queries or would like more detailed information on any of the areas covered, then please do get in touch after the webinar.
So good morning, everybody. So with many more developments taking place than during the pandemic, I thought I'd discuss rights to light, including what they are, how they arise, and what the consequences are if you infringe somebody's right. This is going to be a high-level overview of this topic, but if you do have any queries or would like more detailed information on a certain area, please do get in contact following this presentation. So first of all, what are rights to light? So a right to light is a form of easement. It's a right enjoyed over land that belongs to somebody else. Another way of describing this particular type of easement is that it's an easement that allows a property to receive sufficient natural light to the apertures in a building through the airspace of another neighbouring property. Apertures include windows, skylights and glass roofs. Interestingly, it should be noted that rights may exist even where former apertures have been closed. So now I've explained what rights to light are, I thought it'd be worth explaining what rights to light are not. So over the years, case law has established that there's no right of light in respect of land that has not been built upon. A right to light cannot be acquired until a building with windows to which light is enjoyed has been built. Rights of light do not protect uninterrupted views of the sky from the property or to a property, and rights of light do not stop a property from being overlooked or protect privacy. So how do rights to light arise? Well, there are a number of ways that rights to light can be created. They can be created by express grant. Now, this will normally be documented in a deed or lease, and it arises by way of a reservation in favour of land retained by a seller. They can arise through statute or implied grant, and this is where a document does not expressly grant a right, but there are terms that are consistent with the grant of an easement, or it is implied by the intended use of the property. And they can also arise by way of prescription. So there are three ways that rights of light can be acquired by prescription. Firstly, common law prescription, which presumes there has been a right of light enjoyed as a right since time immemorial. Secondly, the doctrine of lost modern grant, which presumes that if the light has been enjoyed for at least 20 years, there was at some point in the past an express grant of a right of light, and the document containing the grant has been lost. And thirdly, through the Prescription Act 1832. Acquiring rights by prescription is where the right has been enjoyed by a building over a site for a long enough period of time. The most common way of acquiring light is through the Prescription Act 1832. Under this Act, a right can be acquired if the right has been enjoyed without interruption for a period of at least 20 years. It should be noted the 20 years is counted back from the date that the right was asserted or challenged. If the right has been interrupted for a year or more, then this will stop the time from running. And the right also has been enjoyed without any written consent. It should also be noted that tenants can acquire a right of light. Therefore, any developers who want to negotiate a release of rights should consider whether they need to approach both landlords and tenants. Leases will need to be reviewed, as they may reserve all rights of light to a landlord and prevent the tenant from enjoying any light other than with landlord's consent. So how do you defeat a right to light claim? Well, there's a number of ways a claim can be defeated. One of those is unity of ownership. And that's where both pieces of land vest in the same person, then the right of light may be suspended. Another way is through physical interruption of the enjoyment. So if a right is being acquired through prescription, then a physical impediment may prevent the right from being acquired, provided it happens before the requisite 20-year period to acquire a prescriptive right has passed. Another way is a light obstruction notice, and these are often used as a tactic to defeat a claim. So rather than creating a physical interruption, a light obstruction notice can be served on a person whose building may be in the process of acquiring a right to light. The notice has the same effect as a physical obstruction. Now, there is a process that needs to be followed, and it involves firstly an application to the Upper Tribunal Lands Chamber for directions as to what steps must be taken to notify those who will be affected by the obstruction. Secondly, service of the notices as directed by the tribunal. And finally, registration of the notice as a local land charge. It should be noted that these notices will have no effect if the right has already been enjoyed for 19 years and 1 day, because the light obstruction notice cannot have interrupted the 20-year period for 1 full year. And finally, there's abandonment. And this can be very difficult to prove because it must be shown that the owner of the land had a fixed intention never to assert the right to light or to try to pass it to somebody else. If this is agreed between the parties, then this can be documented in a deed of release. So now let's have a look how you bring a claim. So once a right has been established, it entitles the property to receive sufficient natural light to allow the room or space behind the aperture to be used for its ordinary purpose. The impact of that is that rooms used for different purposes will be entitled to receive different levels of light. As a result of this, to bring a claim, it is insufficient to show there has been a reduction in the amount of light. Instead, the loss of light must amount to a nuisance. To bring a claim in nuisance, it's necessary for the claimant to demonstrate that as a result of the reduction in light, the property has been made substantially less comfortable and convenient than before, and has caused a substantial interference with the claimant's reasonable enjoyment of the property. The threshold is much higher for residential properties than commercial properties. If the claimant has a claim, so by that I mean it can show that a right to light exists, it has not been lost and will be interfered with, then the remedy would be an injunction preventing the obstruction or damages reflecting the loss in value. It should be noted that the court can award equitable damages rather than an injunction, which are usually for a larger amount to reflect what the parties would have agreed in a hypothetical negotiation for the release of the rights. Now, many claims can be settled between the parties through a negotiated settlement. Any negotiated settlement normally results in there being a release of the right to light, together with an acknowledgement that any light over the site going forward is enjoyed by consent, so as to prevent any rights from accruing by prescription in return for payment of a fee. Quite often, the settlement will relate to the particular development in question, so that the person with the right can still bring a claim in respect of any future development. So what's the best way to avoid a claim? Well, you need to identify rights to light or potential claims for rights to light early on in the process. You need to consider whether the development can be altered to avoid any claims. And then you should consider serving light obstruction notices. However, as discussed, these will not be appropriate if light has been enjoyed by a neighbouring building for 19 years or more. And if an infringement cannot be avoided, we need to review all the options to ascertain the best way to manage it. For example, would an insurance policy be appropriate? Insurance policies of this nature are normally bespoke and may cover the cost of altering a building to comply with a court order, the cost of new planning permission, litigation costs and settlement fees. If you are considering insurance, then you should put it in place before contacting the relevant parties. Some insurance policies will prevent contact without the insurer's prior approval. Alternatively, a developer may want to consider whether to negotiate a release. Now, I hope you found this presentation informative. Rights to light can have a significant impact on the success of a development, so any developer would be well advised to consider them at an early stage and devise a strategy to deal with any claims.
Good morning, everyone. There have been quite a lot of developments in terms of the legislation and case law in recent months, and over the next 10 minutes or so, I'm going to give a whistle-stop tour of the key changes to be aware of in this area. I'll first look at the Leasehold and Freehold Reform Bill, which has made rapid progress through the House of Commons. I'll then touch on the planned changes under the Renters Reform Bill, before looking at some of the potential changes that are likely to be considered as part of the proposed reforms of the Landlord and Tenant Act 1954. I'll then look at 4 key cases which have been decided in recent months, first continuing in the theme of lease renewals, and then looking at the first cases coming out of disputes under the Building Safety Act. So, starting with the Leasehold and Freehold Reform Bill. This was introduced at the end of November 2023, and its aim is to improve home ownership for millions of leaseholders in England and Wales. It's been described as the most significant reforms to the leasehold system for a generation. It includes reforms on lease extensions, enfranchisement, service charges and ground rent. A key takeaway is that it has far-reaching impact for mixed-use schemes, as it will increase the number of mixed-use buildings which can be subject to leaseholders' rights to manage and acquire the freeholds of a property. It's therefore very relevant for freeholders and investors. The report stage began on 27th of February, when MPs propose, discuss and potentially vote on modifications and additional clauses to the bill. The bill has concluded its third reading in the House of Commons and has now moved to the House of Lords for consideration. It's envisaged that it will be enacted this summer. In the third reading, there were a number of amendments to the bill, and unfortunately it's not possible to summarise all of them for the purposes of this webinar. I'm therefore just going to pick out some of the main proposals of the bill that are likely to be the most relevant to you. Firstly, current legislation provides that a tenant must own their leasehold interest for 2 years before being able to rely on statutory rights relating to enfranchisement and extension. This is to be abolished. Lease extensions will also be increased from 90 years for flats and 50 years for houses to 990 years. Ground rent will be reduced to a peppercorn on payment of a premium, or alternatively capped at 0.1% of the market value of the relevant freehold interest for the purposes of premium calculations with high ground rents. Buildings caught by the legislation will be extended from those with 25% non-residential use to those with 50% non-residential use. Leaseholders will have repeated rights to enfranchise or extend their leases, and leaseholders can choose whether to acquire certain intermediate interests. Leaseholders will also be able to require a freeholder to take a lease back of certain units, reducing the cost of enfranchisement or lease extensions. Importantly, marriage and hope value will be abolished, meaning that premiums for short leases will be reduced, and in enfranchisement claims, the leases will be longer. Landlords will only be able to charge their reasonable non-litigation cost to the leaseholder if there's a very short term left on the lease. There will also be restrictions on the recovery of litigation costs. And finally, there will be a ban on the sale of leasehold houses. This was introduced in the third reading earlier this month. I'll now move on to the Renters Reform Bill. This aims to reform the residential rental property market in England. The bill was introduced in the House of Commons in May last year and received its second reading in October. The government aimed to push through this legislation this year, but royal assent has now been delayed until the court system has been reformed. I'll touch on this in a moment. The main changes include a provision that all assured tenancies will be periodic, with a rent period not exceeding 1 month. Existing fixed-term assured tenancies will become periodic after the end of the 6th term. Secondly, tenants will be able to give 2 months' notice at any time, with exceptions for student accommodation to avoid long vacant periods. Assured short-hold tenancies will be abolished, and as such, the ability to give a Section 21 notice when the contractual term has come to an end will also be abolished. However, the government has announced that this abolition will not take effect until there have been major reforms in the court system to speed up evictions where the tenant is at fault. There will also be changes to the grounds for possession. Currently, if a landlord wishes to occupy their premises, they must give the tenant a written notice no later than the beginning of the tenancy. The reforms provide that a landlord or close family member intends to occupy the premises as their only or principal home, no notice is required, but the ground cannot be used within the first 6 months of the tenancy. There will be a new mandatory ground 1A, allowing landlords to obtain possession if they intend to sell the premises. No written notice will be required, but the ground cannot be used in the first 6 months of the tenancy. Mortgage companies requiring possession do not need to give written notice to tenants, and landlords can obtain possession for rent arrears where the tenant is in 2 months' arrears when serving a notice and at the time of any court hearing, but the notice period prior to applying to court is to be increased from 2 to 4 weeks. There will also be a new mandatory ground for possession where a tenant has been in at least 2 months of arrears 3 times in the last 3 years. Finally, many of you will be aware that the Landlord and Tenant Act 1954 is facing scrutiny. This Act was brought in to give protection to business tenants after the Second World War, with a view to rejuvenating the economy. The Act prevents landlords terminating protected business tenancies unless the landlord can evidence one of 7 statutory grounds of opposition. However, the business and property markets have changed significantly since the Act was enacted. And in March 2023, the government tasked the Law Commission to undertake a review of the Act as part of its strategy under its antisocial behaviour plan to revitalise high streets and shopping centres. The Law Commission's consultation paper was expected to be published as soon as possible this year, but it's now been pushed back to autumn. There are a number of key areas that are anticipated to form part of the review. Firstly, the contracting out process. Currently, tenancies can be contracted out of the Act by the landlord serving a notice on the tenant, notifying it that it was giving up the protection of the Act, and the tenant giving a declaration acknowledging that. However, the process is cumbersome, and the reforms could range from reversing the position, such that leases do not have protection unless the parties opt in, to simply displaying a mandatory warning notice on the front of a lease. Secondly, the basis of determining the new lease terms could change. Currently, the terms of any renewal lease must be based on the terms of the existing lease, and any departure from those terms must be justified by the party seeking to depart. Recently, this has caused issues when reflecting current market practices, particularly in relation to turnover rents and green lease clauses. In a relatively recent case involving JD Fashion, the court rejected a request for a turnover rent on the basis that factoring in a tenant's turnover is having regard to a tenant's business and goodwill built up over the term of the lease, and as such, turnover rents penalise tenants for that goodwill. In relation to green lease clauses, in Clifford Logistics and Scottish Equitable, the court rejected the landlord's request for a prohibition on works resulting in a substandard EPC rating, and it thought that in the 1954 Act in its current form is inhibiting the increasing push for sustainability. Any reform should therefore give greater clarity on determination of renewal terms. Finally, the consultation will look at the opposition of renewals. One of the most frequently used grounds of opposition to a new lease is ground F. This allows a landlord to terminate a lease if it intends to demolish or redevelop a property. However, demolition is not always the best or most sustainable way to redevelop a property, and those landlords who simply wish to repurpose or redesign it currently have difficulty in regaining possession. The reforms may therefore redefine ground F. I'll now move on from legislative reform to recent developments in case law. The first case that is again in the spotlight is the legal tussle between B&M and HSBC. In this case, B&M served a Section 26 request for a new tenancy. The landlord, HSBC, wished to oppose the renewal on grounds of redevelopment, but failed to serve a counter notice opposing the request due to a post-room error. This caused issues for HSBC as they'd entered into an agreement for lease of the property to Aldi. B&M's claim proceeded as an unopposed lease renewal, but HSBC understandably sought to limit the terms of the new lease, requesting a short term with a rolling break right. B&M requested a 10-year lease without a break. The county court ordered a 5-year term with a break on 6 months, operable immediately. B&M appealed and claimed that in granting a break that could be exercised on day one, the judge had not appropriately balanced the rights of the landlord to recover possession against the rights of the tenant to enjoy security of tenure. B&M claimed that the judge put development objectives above security of tenure protection. The High Court found that the judge had properly balanced the interests of the parties. It found that although in some circumstances it may be reasonable to delay the operation of the break clause, a delay would not be appropriate if it would frustrate a development. Keeping with the theme of lease renewals is the case of Gill and Lee News Limited. This is also a case where a Section 26 request was served and the landlord wished to oppose. In this case, the landlord served a counter notice opposing the renewal on grounds A, breach of repair covenants, B, persistent delay in paying the rent, and C, other substantial breaches. The County Court judge found that the tenant had been in breach at the time of the counter notice, but as at the date of trial, the disrepair had been remedied. In addition, the persistent delays in rent payment were limited to a few days, and the other breaches were minor. As the grounds were discretionary rather than mandatory, in order to refuse a new tenancy, the judge had to find that on account of the tenant's actions, it ought not to be granted a new tenancy. The judge exercised his discretion and found that the tenant was entitled to a new lease. The landlord's appeal was not successful. The Court of Appeal found that whilst the tenant's past behaviour was relevant, the grounds remained discretionary, and the overall question was whether it was fair to the landlord to require it to re-enter a legal relationship with the tenant. The Court of Appeal supported the conclusion that there was not enough to deny the tenant a new lease. Moving on now from lease renewals to the first cases which are coming out of disputes under the Building Safety Act. The case of Adriatic Land looked at the recoverability of costs under the Act. In this case, the landlord was required to carry out remedial works to remedy safety defects. Under Section 20 of the Landlord and Tenant Act 1985, without consultation with leaseholders, the landlord would have been limited to recovering £250 per flat, unless it obtained a dispensation order from the tribunal. The dispensation order was applied for and granted, but the ability of the landlord to recover its costs of the application through the service charge was then addressed by the tribunal and upper tribunal. The upper tribunal reviewed Schedule 8 of the BSA, which provided that no service charge is payable under a qualifying lease in relation to legal or other professional services relating to the liability or potential liability of any person incurred as a result of a relevant defect. This included services in relation to court proceedings. Although the court application was made before Schedule 8 came into force, the review of the application was dealt with after its commencement. Therefore, the schedule had retrospective effect and the costs would not be recoverable from the tenants. The final case that I'm going to look at today is the case of Triathlon Homes and Stratford Village Development Partnership. This is a landmark decision concerning remediation contribution orders under Section 124 of the BSA. In this case, Triathlon owned a long leasehold interest and made various applications in the FTT for remediation contribution orders. The applications were made against the freeholder and the original developer, which was the subsidiary of the freeholder. Triathlon made an application against the freeholder because the developer's financial position was precarious and it was reliant on financial support from the freeholder. The freeholder contended that it was not just and equitable for it to be a party to the proceedings, and Triathlon should pursue remedies against contractors and consultants. All the work should be funded by the government's Building Safety Fund. The tribunal rejected this position and found that the making of the order was at the discretion of the court, having regard to the purpose of the BSA. It found that the primary responsibility for remediation was on the developer, but it was just and equitable for an order to be made against the freeholder to ensure that where a development has been carried out by a thinly capitalised or insolvent development company, a wealthy parent company cannot evade responsibility for meeting the costs of remedying the relevant defects by hiding behind a separate personality. The purpose of the BSA is to protect the public by getting the works carried out. Developers, management companies and commercial landlords should therefore be aware that whilst the primary liability will lie with the developer, the other related entities may be expected to contribute to the remediation costs. So that concludes my run through of the key developments in legislation and case law. I hope that you found the information useful. If you'd like to discuss how any of the changes will impact on your business, please do not hesitate to get in touch.
Thank you, Karen. So that's pretty much all we have time for today. Of course, no webinar would be complete without me mentioning our property portal. If you haven't already seen it, please do have a look on our website. There's lots of interesting and useful information and the ability to store all of your property deeds and documents. If any of you are attending UK Reef in Leeds in May, please do drop us a line and let us know. Laura and I will be there. We would love to meet you for a drink and a catch-up. And that's it really. Thank you all for joining us today. If you have any questions at all, please do not hesitate to get in touch with any of us at the details on screen. You will be able to watch this webinar again very shortly, as it will be on our YouTube channel, so please do check it out. Thanks again and have a good day.